of appellant Jeremy Durham. I'd like to reserve 3 minutes for rebuttal.
All right, sir. You may proceed.
Your Honors, this appeal involves an unprecedented assessment of a $465,000 civil penalty against Jeremy Durham, a candidate for the Tennessee House of Representatives in 2014 and 2016 for alleged violations of Tennessee campaign finance laws. Since nothing happens in a vacuum, if the court would indulge me to just briefly give you a little bit of context of what was going on in Nashville between 2016 and 2018 involving Mr. Durham, who was a representative at that point in time. In February of 2016, the Attorney General notified Mr. Durham that the House of Representatives had appointed the state to conduct an investigation into allegations of disorderly and inappropriate conduct by Representative Durham. And Mr. Durham became the subject of intense media scrutiny here in Middle Tennessee. There were salacious allegations made against him that were carried in all forms of media. Those allegations were ultimately never proven. The Attorney General's investigation spawned a number of competing investigations, including the Registry of Election Finance audit that brings us to court today. And that audit was focused on the 2014 to 2017 election cycle. And again, that's the subject of this appeal. Not to be left out of the media frenzy that was going on back in 2016 and 2017, shortly after the registry started its audit, my former colleagues at the United States Attorney's Office here in Nashville opened its own investigation, which ultimately was closed in 2019 with a declination of prosecution in that case. I just wanted to give the court a little flavor of what was going on here involving Representative Durham at the time. By the registry's own standards, the $465,000 penalty was a staggering amount and was unprecedented, again, by how they typically did things over the years. For the 2 years prior to the Jeremy Durham audit, the registry had only issued $60,000 in aggregate civil penalties against all statewide candidates and PACs. I think the court will see when you look at the record and read the briefs that there is an obvious unwarranted disparity between Mr. Durham's treatment by the registry and how other legislators were being treated. Mr. Durham challenged that civil penalty before Administrative Law Judge Steve Darnell. Judge Darnell credited many of the arguments that Mr. Durham made and reduced the penalty by over 75% to $111,000. Much aggrieved by Judge Darnell's measured, sober, and reasonable analysis and order, and I think frankly motivated to keep the registry relevant and in the news, the registry issued a second show cause order, followed by a second final order restoring its original $465,000 civil penalty, unmoved by what Judge Darnell had ruled, effectively making a mockery of the truly independent administrative review of the registry's what I think can fairly be characterized as vindictive and flawed process and excessively punitive against Mr. Durham. Consistent with the adversarial tone that had been adopted by the registry throughout this process, 3 board members publicly acknowledged that the registry would simply ignore Judge Darnell's order and reinstate the full civil penalty amount. And that's exactly what they did. And when you see some of the comments of those board members, the decision was not based on the law or based on anything that Mr. Durham had done, but more about wanting to vindicate what they perceived to be their own power. I think the court can conclude that the conduct of the registry throughout this process was fundamentally unfair to Mr. Durham. A review of the record, I respectfully suggest, reveals that the only competent, reasoned finding and conclusion that was in any way supported by substantial and material evidence, not the ad hominem that had been adopted by the registry, is Judge Darnell's finding, the administrative law judge. And if you'd give me permission, I'd just like to read a sentence of his ruling that I think really sums up where we are in this situation. And this is from Judge Darnell's final order. Quote, "The auditor's assumptions may be appropriate for the audit, but are not permissible under the UAPA. Additionally, the auditor relies on hearsay, speculates about the nature of expenditures, and makes statements clearly not based on his personal knowledge. The auditor's statements based on hearsay, speculation, and assumptions were given no evidentiary weight. The permissible evidence only proved the above found facts by a preponderance of the evidence," meaning the $111,000 that Judge Darnell had found. And I think that is really the answer to the case and the crucial finding that was made by Judge Darnell. He was the only one other than my client that performed any analysis of the line items, the expenditures that were at issue in this case, and he concluded that $111,000 was the appropriate amount. And
let me make sure I understand something. As I understand it, you didn't introduce any evidence, did you?
We filed a notice pleading, a responsive pleading in the form of a letter when the registry first leveled its accusations against Mr. Durham.
But the registry didn't consider that, correct?
And they would not consider it, but I thought it was instructive that Judge Darnell considered it as an answer, is the way that he put it, and he used it to inform his decision, because I think the way he characterized it in his order was that it gave him an idea of what the position of Mr. Durham is and a roadmap of how he viewed those expenditures. But he did his own analysis of the expenditures, and where he saw that the auditor was relying on hearsay or speculation or a misapprehension of what the rules are, I think Judge Darnell appropriately deducted those amounts and came up with a reasonable amount of $111,000.
So back to my original question.
Yes, sir.
The registry did not consider the document that was filed on behalf of your client, correct?
In a very arbitrary and capricious manner, they did not.
All I need is a yes or no.
No, they did not.
Okay.
No,
Now, second question. Did you ever introduce any other evidence other than that?
Nothing other than the oral argument that both sides made in front of Judge Darnell.
Okay. What I'm trying to determine initially is how the registry got one number and how the administrative law judge got something else, if it was a determination of their interpretation of the evidence or lack of evidence or analysis of the law.
I think it was a lack of evidence. Although Judge Darnell used the letter to inform how Mr. Durham viewed the expenditures, if I understand his order, he took a look at what Mr. Meck, the auditor, had done, and where he saw that the auditor was relying on hearsay, relying on speculation, relying on a misapprehension of what the rules were, Judge Darnell excluded those items and reduced that $465,000 down to $111,000. I think that was his analysis. And to me, that seemed to be a fair and reasoned analysis. He's been the only person, other than my client, to really roll up their sleeves and take a look at these expenditures. In Judge Darnell's order, and I know the court is familiar with it, I just wanted to highlight a few things. He reduced the Class 2 civil penalties to that $111,000 number. He found that the registry offered no proof of any intent to defraud by Mr. Durham, which he found to be significant.
Was that not something that the registry determined the administrative law judge failed to properly consider, and that is who has the burden of proof?
And the registry has the burden of proof. And I think that's clear. And I think Judge Darnell supported that as well. Mr. Durham, at that stage of the proceedings, had no burden of proof. He put that letter together, which he believed was a responsive pleading, an answer to what the allegations were.
Did he have counsel at the time that he filed that?
He did. He had counsel and he had advisors, and all of us worked on putting that letter together and submitted it to the registry. But given the attitude of the registry at the time, it could not have been any more adversarial. I am a criminal defense lawyer and a former prosecutor, and that was probably one of the more hostile environments I had ever been in, appearing before that registry. They had clearly made up their mind as to what they wanted to do and didn't really care to hear much from Mr. Durham or his representative. That was the atmosphere that we found when we were dealing with the registry. In looking at the substance of the expenditures, Judge Darnell found that there was no requirement at the time, as the law was at the time, that Mr. Durham had to declare interest earned on campaign funds. That's how he did his methodology of whittling away at that $465,000 penalty. He concluded that no civil penalty could be assessed for failing to disclose interest earned. That's another way that he reduced the fine. He wrote that the auditor failed to even present a prima facie case that certain expenditures were not campaign related. And he noted that the Disclosure Act's definition of what constitutes a legitimate expense is a very broad category. I am out of time, and I reserve 3 minutes for rebuttal. Thank you.
Yeah, thank you.
Good afternoon, Your Honors. Janet Kleinfelter with the Attorney General's Office. I'm here on behalf of the Registry of Election Finance. And Judge Stafford has hit upon the fundamental aspect of this case. This is a case under the Uniform Administrative Procedure Act up for judicial review. This court, just like the trial court, is limited to what's in the record. And much of what you heard just now from opposing counsel is not in the record. There is nothing in the record concerning the registry's assessment of civil penalties in the 2 years leading up to this matter. In fact, that was an issue that was raised. Mr. Durham specifically requested the opportunity for the record to be kept open to present that evidence to the administrative law judge. The administrative law judge, in his order issued on July 8th of 2019, specifically said, I'm leaving the record open for you to present that evidence, to file it with your post-hearing brief. Nothing was ever filed. Instead, we got a post-hearing brief that again referred to newspaper articles, but did not present any additional evidence that the administrative law judge could consider as competent evidence. There was no evidence that was presented by the petitioner in front of the registry, in front of the administrative law judge. The 60-page letter that counsel refers to is a letter that, as we've noted, is anonymous. It's not signed by anybody. It's not identified as to who authored the letter. It is not even fully attributable to Mr. Durham. The registry has a rule that it promulgated under the Uniform Administrative Procedures Act, which says that at a show cause hearing, the respondent has the opportunity to either appear in person and present live testimony or to present a sworn statement. This is in order to comply with due process requirements. Mr. Durham chose to do neither. He did not submit a sworn statement to the registry, nor did he appear at the registry's hearing that took place in 2017. Additionally, when we had the contested case hearing in front of the administrative law judge in 2019, Mr. Durham again chose not to appear to present any sort of testimony, nor did he present any evidence. All of the evidence that he refers to in that letter could have been presented at that time because the ALJ specifically stated that this was a de novo hearing. He was not going to consider anything that the registry done. It was a de novo hearing, and counsel had the opportunity to present whatever evidence they had. Nothing was presented, even when the administrative law judge kept the record open after the contested case hearing to give Mr. Durham the opportunity to supplement the record with the alleged evidence of the inconsistencies in the actions of the registry. With respect to the burden of proof, the administrative law judge did find that the registry had the burden of proof here. That was one of the issues that the registry specifically noticed in its notice of intent to review the initial order, specifically said, we're reviewing this issue of who has the appropriate burden of proof. The registry found that the administrative law judge was wrong in light of the Supreme Court's decision in the Presley case and based upon the plain language of the statute in 210.110, which says that anyone who has been assessed a civil penalty that wants to contest the civil penalty or seek reduction files a petition for a contested case hearing. Based upon the plain language of the statute in the Presley decision, the registry found that the burden of proof was upon Mr. Durham and not the registry. On appeal to the trial court for under judicial review, the trial court agreed and found that yes, the burden was upon Mr. Durham, and that issue is not before this court. Mr. Durham has not raised that issue as a grounds for appeal before this court. In addition, with respect to this argument of substantial and material evidence in the record, that was also not an issue that was raised in front of the trial court. Instead, the two issues, as the trial court noted in its order, the two issues or the two grounds upon which Mr. Durham was seeking judicial review was that the actions of the registry were unconstitutional and alleged irregularities in the procedure. Did not at any point argue that there was not substantial and material evidence in the record to support the decision of the registry. As Judge Stafford has recognized, the evidence in the record is uncontested. It is the sworn affidavit of the auditor who has set forth in his affidavit his years of experience as a forensic auditor, a certified fraud examiner for the Registry of Election Finance. It set forth the explanation of the audit process that he went through. All of the records that the audit was based upon were records that either Mr. Durham provided or that were obtained through subpoenas to Mr. Durham's financial institutions. In short, Your Honors, there's nothing in the record to contradict or contravene the decision by the registry to assess the civil penalties in this case. The civil penalties that were assessed were all consistent with the statutory maximums, as we noted in our brief. With this audit, the registry identified over 300 separate violations of the Campaign Disclosure Act and the Campaign Contribution Limits Act. Over 300 separate violations, each of which was subject to a penalty of at least $10,000, and in some instances, if the amount in controversy was in excess of $10,000, then it would have been that amount in controversy. So Mr. Durham could have been facing civil penalties of up to $3 million. The registry assessed civil penalties of $465,500, and when it went up on review, when the registry determined to do its review of the initial order, they actually reversed the assessment of a civil penalty for the interest issue. They agreed that it was inappropriate to assess a civil penalty for the interest that had been received by the campaign, by Mr. Durham's campaign account, because that was not a clear issue at the time. And so they actually reversed that civil penalty such that the civil penalty was reduced down to $460,500. I'm not going to address the other arguments that have been raised in the petitioner in the appellant's brief unless the court has any questions. I believe that our brief fully responds to those arguments, but of course I'm glad to respond to any questions that the court might have.
Thank you.
Thank you. We would respectfully request that the court affirm the judgment of the trial court.
state is relying on the auditor. Judge Darnell found that the auditor failed to follow the registry's own standard in evaluating campaign expenditures. He also found that an expenditure is appropriate if it's made for a political purpose, and that is a fact-bound determination. He found that the auditor erred, and that's how he arrived at his reducing the $465,000 number. He found that the auditor had erred in disallowing expenditures, and he listed those specific expenditures that were disallowed. He approved, contrary to what the auditor had found, that the investment of campaign funds at the time that was done was perfectly legal. The investments were not loans, and they were not for personal use. And he found that the imposition of the monetary penalties were excessive and grossly disproportionate. And he chided the registry for not looking at their own history and how they had handled these matters in the past in similar situations. He found that there was no proof that Mr. Durham had acted intentionally. There was no proof that he had converted any campaign contributions to his personal use. There was no proof that any of the expenditures were not made for a legitimate campaign purpose, and significantly found that no individual suffered any harm. So it just seems grossly disproportionate, and the court has the benefit of my brief in terms of the excessive fines clause. In the history of the registry, there's never been a penalty imposed anywhere close to this, and it just seems so out of proportion to what these violations were. Many of these were first-time mistakes that were made by a legislator that had an active campaign and had many contributors, and there was no intent to defraud the registry or violate the law in any way. And I would ask the court to reverse the decision of the trial court.
Thank you. Thank you, counsel. We appreciate your argument. We will review the record and attempt to file an opinion at the earliest possible time. I think that concludes the call of the docket for today. We'll be in recess until the call of the docket by the Chief Judge.